I was in ninth grade English, and we were reading Lord of the Flies, which, if you recall, is a book about the chaos that ensues when kids try to govern themselves on a stranded island. When my ninth grade English teacher asked a question, she said, "Can you imagine if our world was governed by children?" At which point my friend beside me said, "What's there to imagine? Congress is in session." And I mean fair, given that at least the kids on the island got stuff done. Likewise, today I want to discuss not just the implications of youth involvement in these spaces, but one critical space in particular. This building behind me, the Johnson County Courthouse, just a couple miles down the road, where in normal days you'd see this courtroom be occupied by adults. Yet on Tuesdays, it takes a transformation of its own. Where you normally see it occupied by adults, you see young adults serving as jury members, as prosecution and defense attorneys, as the respondent, and yes, even the judge is a young adult, aged 12 to 18. Now, I'm sure you're asking yourself, why? Why are we having young adults serve in courtroom spaces? And it's a fair question, one I hope to answer, and why young people's involvement in political decision-making is crucial to inspiring change. But first, I want to provide some context. The Department of Justice just recently commissioned a report finding that these youth court programs across the U.S. are expanding rapidly at a rate unprecedented. It's for two key reasons that we can examine in today's speech. First, that individuals who engage in youth court procedures gain invaluable civics education. And the second is that it clears court dockets off of otherwise already overburdened court systems. Now, I'd like to explain how this is achieved through an example. So let's all suspend our disbelief for just a moment and imagine we have this student before us today. Now, continuing with the Lord of the Flies analogy, let's name him Ralph. Often rebellious, rambunctious, and infrequently capable of making rational decisions. Ralph one day comes across a piece of toast, and he's sitting outside. But then a couple in a 2001 Honda Civic comes rolling down the street and stops at the stoplight. Now Ralph, in a moment of a pure lapse of judgment and not knowing what is the better turn to take for his civilian nature, decides to launch his piece of toast right onto the front dashboard of the passing vehicle. Why does he do so? Well, in police report investigation, we're not exactly sure, but he described it for quote-unquote the meme. Yet thankfully, as this car continued to accelerate, this piece of toast flew off and no one was harmed in this incident. However, we can see quickly how this individual and this couple was greatly fearing for their lives. I mean, I too would as well, given that toast were landing on my car windshield window. As such, this couple called 911, asking a police report to conduct an investigative analysis as to what happened and why Ralph threw this piece of toast on their passing vehicle. The police, conducting a thorough investigation, files a notice to appear. And now Ralph is told that he has two options. Ralph can either, one, approach juvenile district court, or number two, can be sent to youth court. Now, what's the distinction? The first is that juvenile district court is often reserved for individuals who commit crimes of a typical level of severity. The second alternative is youth court, in which individual students, often misdemeanors of first-time crimes, can appear before this peer rehabilitative and restorative justice approach to justice. Now, I in no way mean to diminish Ralph's actions, nor in youth court do we seek to trivialize them. However, I think we can all agree that judicial courts have a lot more priorities than going after airborne breakfast foods. As such, these youth court procedures provide invaluable civics education and a restorative approach to justice without necessarily overburdening the case dockets. So what does youth court look like in practice? I'm sure you're asking. Well, it has all the main trial structures that we typically observe, except for three key exceptions. First, instead of describing the individual as a criminal, we describe them as respondents. There's a couple of reasons for this. The main one being is it's not often productive to label individuals at this young an age as criminals. Instead, seeking them as respondents or people capable of responding to their crimes and able to learn and grow from that virtue better enables us to contribute to their restorative path to justice. The second alteration to the youth court procedure is that these individuals who appear before us have already admitted involvement in the incident. As such, we as attorneys don't actually spend time debating whether or not Ralph would have thrown the bread. That is established. Rather, to what extent we should sanction Ralph to ensure that he is given the services that he needs. Third and finally, is that in this youth court procedure, we can't subpoena anyone, thankfully. The court procedure, as you see here, with the judge, a prosecution, a defense attorney, and the jury, is all composed of young adults. Now, with this basis in mind, as to how youth court operates and the ways in which it engages with individuals, I think I can now tell you the story in which I named this speech today, as to why a father engaged in this youth court process thanked me for prosecuting his son. I think that story reveals a lot as to the insight that these youth court programs provide. So, like any story, it began much like in this courtroom we see here today. The individual juror and the bailiff told all to rise. Johnson County Youth Court is now in session with the Honorable Judge presiding. He then asked me, the prosecution, to state my appearance, at which point I stood, Rishabh Barve for the prosecution, Your Honor, and looked to my right. There stood the student offender, the respondent. And at that moment, like many of us student prosecutors feel, we felt the villain for sanctioning him with community service and community workshops. But often this is the case. Yet we overlook the fact that the alternative is much worse. That without youth court programs, they'd be instead sent to rehabilitation centers without any of these services promised to them, and also with juvenile district court fees much higher than those which youth court sets upon them. And as such, I remind myself constantly that this serves as a better alternative, despite being labeled as, quote, the villain for prosecuting these individuals. Yet often what we don't see is the parents, who will naturally take off their frustration with the youth court process, describing it as quote-unquote unnecessary, stupid, often dismaying its concerns. Yet, it is our hope, and as such I continue to speak, as the judge lifted me up to say, prosecution, please provide your opening statements, in which I did. I explained how the individual committing this crime was in fact responsible, and how we should continue to hold them as such. And then something unique happened. After giving my opening statement, I turned around and caught a glimpse of the offender's father. And he was smiling. That's not something you see every day. So lost in thought, I barely heard the judge dismiss the jury members to return to the jury verdict box, and then that father called me over. He sat me down and he said two words which I'd infrequently heard in the youth court procedure before. He said, "Thank you. These sanctions are what my son needs right now, and after seeing that, I'm confident that my son will never step foot in a courtroom again." Thank you. This time I said it, but my words felt inadequate. How do you thank somebody who's given you so much in return? You see, these youth court procedures are not just in a vacuum, but they exist in this space which we call restorative justice. And in that moment, that father reinstilled in me the belief that perhaps these restorative approaches to justice can and do work. And so I actually took it upon myself to craft and author research, trying to examine to what extent does it. And so this took me, this last October, to the Lewisburg High School Supreme Court Justice meeting, in which I met with Kansas Supreme Court justices. Behind me is Justice Eric Rosen, in which I engaged in discussion with him as to how the youth court procedure operates and how individuals might continue to evaluate rehabilitative practices across the state. What I mentioned to Justice Rosen especially was this story, how this father, bearing a history of disenfranchisement due to the justice system, uniquely trusted in restorative justice, and how we can expand that trust across the states. In doing so, just a couple weeks later, the founders of this TEDx event reached out to me, and I knew exactly what I'd be speaking about for this event. Now, in trying to attempt to find a solution, I authored this research project behind me, the logistics of which I'll skip before, but it provides you a brief clarity as to what I attempted to determine, which is this fact here. My hypothesis was this: if individuals have an active voice in the youth court procedure and rehabilitation programs, that is, they don't just have a passive act, instead they're able to justify their verdict, explain to individuals how they came, then they'd be able to more likely recall facts. And that's exactly what we found. From an analysis of over 1,060 scored responses across youth court jury dynamics from the past several months, currently under review of the IRB panel of this institution, we found that a 72% improvement in fact retention among jury members. This finding is wholly significant. It shows that young people want to not just put a face in the youth court procedure, but they instead want to be able to speak on their behalf, to restore individuals through their words, and explain the verdicts they come to. In doing so, they not only form a better understanding of the youth court procedure, but they are 72% more likely to take away facts that contribute to their rehabilitation metrics and understanding moving forward. Now, with this research informing my talk today, I think there are three key takeaways we can all implement in our daily lives in order to ensure that young people have access to political decision-making and inspire change. The first is we can amplify young voices. Easier said than done, but I believe that there are several opportunities, especially in Johnson County, which enable us to do so. Now, amplifying young voices takes many forms, but so often we reserve this right to individuals who have access to these opportunities. I encourage everyone in this room to sit in on a youth court hearing. It's really just down the street, a couple minutes away, and see for yourself how individuals are able to amplify their voices in restorative justice programs. Now, the second thing we can do is we can practice gratitude. If there's any question I want to answer in this speech today, it is how gratitude has uniquely enabled me and so many others to contribute back to our communities. Gratitude in and of itself cannot be practiced on a one-time occasion, but rather something you consistently do. Reach out to your legislators, your social workers, and the individuals who make programs like these possible. Now, the last bit of advocacy I have for you today is to redefine empowerment. So often we tell our young people that the only way to be empowered is to hold a position of power, and that is a prerequisite to necessarily fostering change. I believe we can uniquely dismantle this truth. In doing so, we encourage our young people that to be empowered does not necessarily mean holding a title, but instead seeking that title out for yourself. It can mean an active service in any capacity, whether in youth court as described above, or authoring research yourself to understand the implications of reasoned verdicts. I believe collectively, we can continue to strive for a world in which young people are multifaceted in their approach of accessing restorative justice. And it begins with just us in this room.